Being charged with a felony can feel like your life is already over. You may be thinking about prison, work, family, and your record. You may wonder whether anyone will ever see you the same way again. So let's answer the big question right away. Yes, a felony case can be dismissed before it becomes a conviction, but dismissal is not automatic. In this video, we'll cover how felony cases can get dismissed, what with prejudice and without prejudice mean, and why a dismissed case may still show up on your record. The most important question is not just is it over, the real question is can they bring it back? A felony charge is serious, but a charge is not the same as a conviction. A felony case can be dismissed for several reasons. Sometimes the evidence is too weak. Sometimes a key witness is unavailable, inconsistent, or unreliable. Sometimes the police search may have violated someone's rights. Other times, there may be a problem with the paperwork, the timeline, or the way the case was brought. Pretrial motions can raise issues like speedy trial violations, charging document defects, and suppression of evidence. They can also raise discovery problems or other legal defects under federal criminal procedure rules. That does not mean every motion wins. It means the defense may have legal tools before trial. Dismissal can also happen because the prosecutor decides not to continue. Maybe the case is too weak. Maybe new evidence creates doubt. Maybe continuing no longer serves justice. The American Bar Association says prosecutors do not have to keep every charge the evidence might support. They may consider fairness, harm, and public interest. They may also consider consequences, including rehabilitation, when making charging decisions under prosecution standards. There can also be diversion programs. In some places, completing a court-approved program may lead to dismissal. But dismissal usually takes action from someone with legal authority. That might be the prosecutor, the defense attorney, or the judge. It usually does not happen just because the defendant explains their side in court. There are different paths to dismissal, and they do not all work the same way. First, the prosecutor can ask to dismiss the case. In federal criminal cases, the government may dismiss an indictment, information, or complaint only with the court's permission under Rule 48. State rules can be different, and most felony cases are handled in state court. So local procedure matters. Second, the defense can file a motion. A defense motion is not just saying, "I didn't do it." It usually points to a legal problem. For example, the defense might argue that evidence should be suppressed because of an illegal search, or they might argue that the charging document is defective, or they might raise a speedy trial issue. Federal rules recognize that some defenses and objections must be raised before trial when the basis is reasonably available under Rule 12. That means timing can matter. Third, the judge can grant or deny certain dismissal requests. A judge may also dismiss for unnecessary delay in some situations under Federal Rule 48. Speedy trial rules are meant to protect people from excessive delay. Exact deadlines and remedies depend on the law, the facts, continuances, and who caused the delay under speedy trial standards. Be careful if someone says, "The case has been going on too long, so it must be dismissed." Delay can matter, but it is not always that simple. Dismissed does not always mean gone forever. There are two phrases that matter, with prejudice and without prejudice. A dismissal without prejudice usually means prosecutors may be able to refile the case depending on the jurisdiction and order. That does not mean they always will, but the door may still be open. Refiling can depend on deadlines, evidence, court rules, and local law. A dismissal with prejudice is usually stronger for the defendant. It generally means prosecutors cannot refile the same case based on the effect of the dismissal order. That difference is huge. If someone tells you, "My felony was dismissed," the next question should be, was it with prejudice or without prejudice? And do not guess, read the actual court order, ask your lawyer, ask what the exact wording means in that court. The reason for dismissal also matters. A case dismissed because of a correctable paperwork problem may not be the same as a case dismissed after a serious constitutional violation. Even when the case is truly over, there may still be one more problem. Dismissal does not always erase the record. The criminal case may be dismissed, but the arrest record may still exist. The jail booking record may still exist. Court files and background check traces may still be out there. Dismissed and expunged are not the same thing. Expungement or sealing is usually a separate process. Some states allow dismissed charges to be sealed or expunged, but eligibility and procedures vary widely by state law. And even after sealing or expungement, some records may still be visible to courts, prosecutors, or law enforcement. Certain licensing agencies may also have access depending on the rules, so if your case gets dismissed, that is important. But it may not automatically clean up every record. So, can a felony case be dismissed? Yes. A felony case can be dismissed before conviction. That can happen because of weak evidence, legal problems, or delay. It can also happen through prosecutor discretion, diversion, or negotiations, but the details matter. With prejudice and without prejudice are not the same. A dismissal may end the case, but it may not erase the arrest or court record. If your felony case is dismissed, get a copy of the order. Check whether it says with prejudice or without prejudice. Ask whether prosecutors can refile, whether any charges are still pending, and whether you qualify for expungement or sealing. Keep copies of your court paperwork and do not assume online records update automatically. Also, do not miss court just because dismissal seems likely until the court says otherwise. Treat every court date as serious. A pending felony is serious, but it is not a conviction. There may still be defenses, options, and next steps worth taking. If this helped, like this video, subscribe to Fresh Start Society, and visit freshstartsocietyhq.com for more information.